In other news, Section 27 has launched a judicial review application in the Limpopo High Court in Polokwane on behalf of 50 former matric learners from Baphutheng Senior Secondary School. The application challenges decisions that found the learners guilty of group copying during the 2024 matric exams. The learners are unable to progress with their studies or their careers as their matric results remain inconclusive following these cheating allegations. So let's unpack the story now. We're joined by Section 27's Thato Gaffane. He's an attorney at that organization. Thato, thanks very much for your time. It's great to have you on. So this is not to be confused with the copying scandal of last year, right? The copying scandal of last year involved, I believe, some basic education officials. There were allegations that the child of one of the officials had access to some of the exam papers there. So that's a completely separate story. This is a copying scandal from 2024. Just take us back to the allegations involved there.
That is correct, Michelle. And I think it's important that we distinguish between the two incidents, because on the other hand, we're facing a regrettable incident where an official within the department has leaked a paper of the National Senior Certificate examinations, and that has devastating consequences for the integrity of the examinations. And on the other hand, what we're facing in this situation is a group of 50 matric learners who were taught in an under-resourced school which didn't have enough textbooks, and teachers came up with creative teaching methodologies to ensure that these learners are able to retain knowledge, which they would otherwise not have access to because they don't have textbooks. And they used methodologies such as singing, as recitation, as well as repetition. And so when they set for the economics and business studies paper 1 exam, they were prepared because they were taught through those particular methodologies. What then happened is when they wrote, and during the marking process, that was detected that there were similarities in the answers. During that time, no one was questioned about why there is the similarities in the answers. The invigilators were not asked anything. The teachers were not asked anything. Even the principal of the school was not consulted to ask why there are particular similarities in the scripts. And the learners proffered an explanation for this. And they say, because we were taught in a form of a song, we obviously reproduced lyrics to that particular song. And that's why there is similarities in our answer. That explanation was unfortunately not tested in the disciplinary process, and the MEC in the appeal also failed to test it. And as a result, they were found guilty in the disciplinary process, and the appeal that Section 27 filed on behalf of the learners was dismissed by the MEC.
Gosh, so the learners, Section 27 will argue on their behalf as well that there was no cheating, that there was never any cheating, but it was merely the form of study that they used that influenced the way they wrote down their answers.
That is correct. And I think it also brings in the element of inequality, because we're dealing with a school where learners are studying in mobile classrooms, which are literally falling apart. And you can see they've aged. They don't have enough learning and supporting materials. They don't have a library. They don't have textbooks to rely on, and teachers have come up with creative methodologies to ensure that these learners are able to succeed and have the same benefits that other learners in other areas and affluent areas in South Africa have. But unfortunately, that was interpreted as some sort of criminality. And it's really unfortunate, because what also happened during the disciplinary hearing was these learners were not offered an opportunity to give their side of the story. They were just told, you're guilty, just admit it. The people that came before you admitted that they were guilty, which was a complete lie. And you also see the tactic that was adopted in interviewing these learners, that it's completely irregular, it's completely unlawful, and it's really sad that the MEC could not overturn that process, which was so grossly irregular.
Well, it certainly does seem so, if everything you're saying is true, Thato. Has Section 27, and I'm sure the answer is yes, but has Section 27 contacted the relevant education authorities to make sure that this version that students have put to you is tested?
It's unfortunate, Michelle, because that opportunity is within the first disciplinary hearing where the learners were there. They were there with their parents, and at the time, some of them were children. They were 17 years old. And the questions that were put to them were so inappropriate, some of them which we can't even say on a public platform like this. And teachers were told, and the learners were told, teachers were on TikTok while you were writing exams. This is why you had an opportunity to cheat. You were giraffe copying and all of these other things. And all of these other extra allegations are now being put to the learners. The evidence was never given to them. There's actually no evidence at all. The only evidence is the similarities in the script. We had the opportunity through the appeal to ensure that that version is tested. We provided videos to the MEC to say this is how the learners learned. These videos are dated April 2024 and September 2024. You can see that this is how they've learned. And luckily, one of the video that we had was the exact question that came in the examination. And this is where they were reciting something around a recruitment process. And they say it in the exact same word. And it's all the learners in that video saying what they've been taught, and they reproduce that information. And unfortunately, the appeal was still dismissed.
And in the meantime, if indeed it gets to a stage where this version is tested, Thato, these learners have lost now essentially a year of their careers, a year of their further study.
It really is unfortunate, Michelle, and it's really had devastating impact on the learners. Some of them have attempted suicide because they simply just could not stand the stigma that's being attached to being a cheater, someone who tried to defraud the system. And I think the other thing that contributes to the harm, the psychological harm that these learners are facing, is the amount of time it takes for the department to get back to them. I mean, the regulations require that after the disciplinary hearing, they must get an outcome within 14 days. They went for the disciplinary hearing in February and only got an outcome after many protests, after so many letters from Section 27, only in July. And even when we filed, in June, and even when we filed an appeal in June, we only received an outcome in September. So that's a full year that the learners have lost, an opportunity to study. I mean, say they were, for example, successful in their appeal, they would have not even been able to apply for university in the upcoming year just because of how long it took the department to get back to them.
Yeah, absolutely. One of the statements that you've made at Section 27 is that learners from these under-resourced schools have been punished not for misconduct, but for succeeding through methods shaped by poverty and by necessity. That's a damning statement in terms of what it says about the department, and the province.
That is correct, Michelle. Not only for the department, but for South Africa's constitutional dispensation, because we are now in an era where a lot of people are still struggling. I mean, we're seeing it's being reported on the news. A lot of schools don't have infrastructure. A lot of schools are struggling with the National Nutrition Program. And these are learners who are right at the center of those situations, and they're trying to make the best out of the situation. They don't have textbooks. The teachers come up with creative methodologies to ensure that they're able to retain that knowledge and that they're able to succeed like every other learner who has access to those materials. And just when they do that, they get punished for it. And it really is unfortunate.
Thato, tell me something. Did the educators involved in this case, the teachers who were involved in teaching these learners these study methods, as you mentioned at the start of our interview, practical methods to ensure that learners could understand and retain content. And part of this was, as you said, group recitation, subject-based songs to memorize key concepts, and the list goes on and on. But it was around reciting these concepts as a classroom together over and over again. And that would explain the similarities in their answers for the exams. But did these teachers have an opportunity to speak to the education department or Umalusi about these study methods and the reasons why their answers would have been similar?
It's unfortunate, Michelle, because the teachers or even the former principal who was the principal at the time this happened was not consulted at all. They were not consulted. Their input was not required. Even in the disciplinary hearing, the MEC did not reach out to them when she was considering the appeal. And so we only have affidavits now where we were engaging with teachers. For example, the former principal deposed to an affidavit indicating that this was the methodology that was adopted and this is why it was adopted, and also just saying that that could have been the reason why those answers were similar. None of the teachers that we spoke to, who are subject teachers, as well as the invigilators who were invigilating those two particular subjects, indicated that they were consulted by the department, and both the subject teachers say that because of that particular methodology, it is probable that that would have been the outcome. And the invigilators also are under duty to report if they detect any form of irregularity. And you would imagine that something like group copying is something that would be so much visible in the examination room that it would be easy for an invigilator to detect. None of the invigilators reported that, and none of the invigilators we spoke to indicated that they picked up any form of irregularity.
So when does Section 27 go to the High Court with this case then, Thato?
So we're currently in the process of reaching out to the Deputy Judge President to ask for an expedited hearing, just because of the psychological harm that this case continues to have on the applicants. I mean, we certainly don't want a situation where another learner turns suicide and there still isn't any form of assistance. The learners have reached out to the Department of Social Development to ask for psychosocial assistance, and unfortunately they were told they're just too many and they can't be helped. And so what we're trying to do is to get an expedited hearing, but also a case management from the Deputy Judge President in Limpopo to ensure that the department is held on a leash to ensure that they're on time with their court responses and in terms of filing pleadings, because we've really struggled with them over the past year just to get the outcomes, and we don't want that situation to continue. So we'll be waiting to hear from the court once we've sent our correspondence to them to ensure that they're able to give us an expedited hearing.
And in the meantime, we should get comment as well from the Limpopo Education Department insofar as what has been a damning decision against these 50 matric learners accused of group copying despite a serious lack of evidence. Thato Gaffane, let me thank you for your time, and you'll keep us up to speed how those conversations go with the Deputy Judge President so that this case is heard urgently.